Hi, everyone, and welcome to the Watchdog Live. My name is Taylor Hudak, and we are in London covering Julian Assange's full extradition hearing. I am joined right now by my co-host Tarek Haddad and special guests Sarah Mabrook, Nathan Fuller, and Kevin Gustala. I know, Tarek, that you were able to be present in the courtroom today. Today was the third day of the extradition hearing. Remember, it began on Monday, the 24th. So, Tarek, I will hand it off to you to kind of summarize what happened these past few days.
Sure. Firstly, thanks everyone for being here. We started off on Monday and we kind of heard the prosecution's version of events and laying out the charges, and we started to hear from the defense and kind of pushing back against some of those charges made, and we'll get into some of those. And then today we got into specifically more about the specifics of the extradition treaty between the United States and the UK. I think all four of us here, except for Taylor, were in court today. It was kind of a long slog of a day where everyone was kind of battling to keep up with all the
thrilling
legal
case law.
Yeah, but let's put it out to you guys. So it was, a lot of law, but what was kind of interesting, or what jumped out for you guys in terms of what took place today?
Yeah, so it was all about the 2003 U.S.-UK extradition treaty, and Julian Assange is being extradited under this treaty, but the U.S. government, which has a CPS prosecutor in court here in London, is arguing that it should extradite him under this treaty, but actually he shouldn't receive certain rights under this treaty. What was discussed today was largely about the political offense exception in that treaty. It says that the UK should not extradite to the US for political offenses, of which the defense argues the Espionage Act is clearly a political offense, that anything against a head of state or a state is a clearly political offense. But the government argues that even if it is, that doesn't matter, that the UK should just rule under UK domestic law. And because the US-UK extradition treaty was ratified in the US but not in the UK, that it shouldn't apply to Julian Assange. So the government wants to say that we can extradite him under this treaty, but he gets no rights from it.
Any further thoughts on that in terms of, that US is saying that this protection is not going to be available to Julian, even though, we heard in the court today that this protection was almost like a standard bearer across all extradition treaties across the world. I think we heard that it was in the UN's model extradition treaty, it was in the Interpol's conventions around extradition, and the European conventions rulings around that in particular.
There was a moment, I believe, where the judge said something to the effect of, do you think Parliament not having this exception in the Act somehow trumps the Magna Carta, which was kind of a jarring moment when you think about it, because we were talking about arbitrary detention and whether what they're doing with Julian Assange is abusive. We know the Magna Carta going back more than 800 years now, or close to 800 years now, and that basically is one of those things that gives citizens around the world those due process rights that are valuable. It's been a model for many different countries, including the United States, and for the judge to very casually ask the ask the defense for this confirmation. It's just a very startling moment. But what struck me in these proceedings, which we were very deep in the weeds of case law, it's hard for you to follow because, I'm an American journalist, so I don't know UK law, but we have journalists from all over the world who do not know British law or what is happening it's in terms of the domestic law. And you could tell by the way that the prosecutor and the judge were working with each other that the prosecution was doing the bare minimum, as they've been doing all week, in making their rebuttals to the defense. But then the judge was already helping the prosecution before the prosecutor even started to give their response to the defense. So, for example, the defense started the morning talking about what constitutes political offenses, saying these are examples that treason, sedition, and espionage are political offenses. They wanted to outline this case. They wanted to show how the indictment has political offenses, and she stopped the defense and said to them, I don't really care about that. I want to know why this is relevant to UK domestic law. I want to know why I should care that you believe there are political offenses, because I don't think this actually matters as far as our law, because we don't have to abide by the treaty. We can just abide by domestic law.
So, Sarah, I want to get your thoughts in on this as well. I know that today there was discussion about the U.S.-UK extradition treaty versus the Extradition Act. Can you talk about that and how it was presented in court?
Actually, I found it very confusing. So I'm hoping that you can fill me in, because there was something very confusing about the dates when the extradition treaty was actually ratified, which is in 2007, which is, as I understood, the same time that the act. There was some sort of confusion about.
I don't think you're alone in that at all. I think this is a point that has really confused many people. So if we could all maybe discuss that a little bit, or even discuss why this has been such a point of confusion for many people and many journalists in the courtroom.
Yeah, so there's the U.S.-UK extradition treaty, which was written in 2003, but it wasn't immediately ratified by both parties. But so it was written in 2003. It's the U.S.-UK extradition treaty of 2003. And in that same year, the U.K. domestically, the Parliament passed the Extradition Act of 2003. And so the treaty between the U.S. and the U.K. contains this exemption for a political offense, saying we can't extradite for a political offense, and that includes espionage and sedition and treason and things like that. But that exemption, which is common in many extradition treaties around the world, was not in the Act, and not in the domestic UK Act. And so the government wants to argue that that should take precedence. So that was passed in 2003 in Parliament. But in 2007, the U.S. ratified the U.S.-UK extradition treaty of 2003. It's definitely confusing. But they did not remove that bar, the provision that says you cannot extradite for political offenses. So the defense argues that that means that the U.S. and U.K. essentially agree that you shouldn't extradite for political offenses, even though this 2003 Domestic Act doesn't have that bar. It doesn't say that you shouldn't have the bar. It just is silent on the matter.
I think it was interesting because the prosecution argued that the lack of this protection meant that Parliament had intended that this protection wasn't in place. But I think what the defense was saying is that actually, no, it was more of it was silent. It doesn't say whether this protection. I think that's just in order so it can be open, because the act is relevant for all countries, right? Yeah.
Right.
So so I think there was that being done by the prosecution to kind of make the claim that this being absent was their way of indicating that they don't want this protection, and there seemed to be very little pushback against that point. But I thought that was specifically there so it could be valid across different countries. And the point that the defense was making is that if there was a treaty that kind of goes beyond the act itself, then the protections under the treaty, if you are afforded more protections under the treaty than in the act, it's the more generous version that's applied.
Right, and the U.S. ratified this treaty, and as the defense noted, they did that because they don't want to extradite their own citizens, but when it comes time to extradite one to the U.S. has this request. They say that they want it no matter what. They don't care about the political exemption or anything like that. So it's actually politically really dangerous. The U.S. gets to extradite as many people as it wants from the U.K. to the U.S., but so few the other way. I think it's something like 200 to 10. The numbers are in favor of the U.S.
I don't know how many people here are familiar. We talked about this a little bit earlier, of the Harry Dunn case. I don't know have you heard of that at all? Yeah.
Heard of it, not in detail, but definitely heard of it.
Yeah, I'm not as familiar with it as I would like, but I believe that a British individual, Harry Dunn, was killed by a woman called Hannah Scatola, I believe. she's a U.S. citizen, but she was working for GCHQ after she killed this. I think it was a young 16-year-old boy, I believe. She's seeking asylum in the United States now, and they're refusing to help with her extradition back to the UK. So that's kind of, and I think the defense for Julian Assange kind of alluded to this, of how they're seeking extradition on one side, but then kind of when it's the flip, that it's not being provided.
Harry Dunn's family is very aware of this contradiction and have said that if they're not going to send her this way, then Julian Assange shouldn't be sent to the U.S. And it's very clear that there's a extreme power imbalance there.
So just to shift topics a little bit, just to backtrack to provide viewers with some information. If you're just tuning in right now, this is the Watchdog Live. Kevin, I know that Chelsea Manning is very much tied to this case as well, and you have reported extensively on her case. You've also been live tweeting throughout the court hearings. So can you talk about how Chelsea Manning was brought up in court, not just even today if she was, but I know yesterday she was. If you could talk about some of the revelations we learned about that as well.
Yeah, yesterday Chelsea Manning was quite the focus. I'd say that she's irritated and vexes the prosecutors. We heard the prosecutor, James Lewis, say that she had made a self-serving statement during the court-martial back in 2013. This statement is just the statement of a co-conspirator, that she's constantly trying to further and help Julian Assange, and that we shouldn't trust this statement. But the defense is relying on it as, and these are their words, the best chronology for understanding Julian Assange's, what happened with these disclosures to WikiLeaks. It's really the best record that we have publicly, but also it's clear that the defense is using it in order to guide their own in order to guide their own rebuttals to what the prosecution is putting forward. And the reason why it's such a problem for the prosecution is because Chelsea Manning's timeline does not match up with their timeline, and also the arguments that they make about what Julian Assange and Chelsea Manning were doing together, which, by the way, let's be clear, we have a source, Chelsea Manning, and we have Julian Assange, the journalist. So when we're talking about this, we're talking about a timeline of events between a source and a journalist, and they want to say, no, we actually have a timeline of events between a hacker and someone who's an insider, who WikiLeaks was recruiting and turning into a spy, who would go through databases that she was able to crack passwords to get into, or just had access. She could abuse her access, and then she could release these files. And the focus of their allegations is this most wanted leaks list from 2009 that has a bunch of different documents that most people have no idea what they are, but they were suggested based on the interest of journalists, human rights activists, people who were involved in non-governmental organizations. These were what governments were trying to conceal from the public at the time, and they related to high-profile events like wars that were unfolding, conflicts, etc. And they want to say that Chelsea Manning used this as a roadmap. It didn't work in 2013. Nathan could speak to this more, but when David Coombs, her attorney, was defending Chelsea in the court-martial, he made it very clear that this was not any part of the defense that could hold up. And the prosecution really didn't go that hard at this. It's incredible to me that the prosecution against Julian Assange is not only recycling a case against that was used against Chelsea Manning and recycling it to use it against the journalist in this case, but is also going even a step further to then use this most wanted leaks list as a way to go after Chelsea Manning. And like I said, it doesn't match up. We heard the defense go through each of these sets that were released, which for people who are following along, just to make sure everyone understands what we're discussing, We're talking about the Afghan war logs, the Iraq war logs, the U.S. state embassy cables, the detainee assessment briefs, and we're talking about these rules of engagement files that were disclosed along with the collateral murder video. And so the defense very meticulously went through in such a way to make sure that the judge understood that all of these files had their own reasons for being disclosed. The motivation that Chelsea Manning had was not connected to Julian Assange, was not connected to whatever Julian Assange wanted to accomplish. It was all about what Chelsea Manning wanted to do alone. This is her agency. But as you can hear in the prosecution's argument, the entire time that they're making these statements in court, they have to remove agency from Chelsea Manning. They have to say Julian Assange is this anti-American, hostile, hacktivist person who wants to destroy intelligence agencies. We know Mike Pompeo calls WikiLeaks this non-state hostile intelligence agency. So they treat WikiLeaks like a organization that's at war with the United States. And to them, Chelsea Manning's a recruit who can't think for herself. And even today, while she sits in a jail cell in Alexandria, Virginia, having tallied up over $325,000 in fines because of her resistance, having been in jail for hundreds of days now. We're fast approaching the date that marks a year in her resistance. They still believe that that is not something she's doing on her own, that she has been put up to this and is doing it to serve Assange and WikiLeaks.
Mm-hmm. And even if we accepted the U.S. government's timeline of events, it makes out, or the portrayal of it makes it out that the act of Julian Assange seeking information, which they term as like soliciting, as something that's illegal. But this has come up plenty of times, is that this is no different than what journalists do every single day, right? It is, even if Chelsea Manning didn't have agency and it was Julian egging her on or whatever, that doesn't make it any more criminal, right?
That would be totally fair. Yeah.
And to be clear, we learned that she was trying to access video games. Can one of you explain that in a greater depth? I know that was sort of a misconception.
Sure, yeah. If I could give a quick little context first. So Assange is charged under 18 counts. 17 of them are espionage, and the 18th is a conspiracy to commit computer intrusion. And while this has been talked about by the DOJ as a hacking charge and by others as just a computer charge, it's really a conspiracy charge that kind of unlocks the other 17, because as Kevin was saying, it's really the key element to this whole narrative of Assange coaching and working with and trying to get more from Chelsea Manning throughout her time. It's very important that the U.S. and Chelsea Manning disagree on the timeline. They say that she started way back in 2009, when she says that she started in 2010. But yeah, so the hacking charge, the allegedly hacking charge, is what we talked about at length yesterday in court. And the defense explained that, so our common understanding has been that Julian Assange attempted to help Chelsea Manning crack a password to use an admin username in a database that she already had access to otherwise. And so they claim that this would help her use this database and continue to steal documents anonymously. But what the defense explained today was that wouldn't anonymize her, that wouldn't help her do anything more secretively, because the military tracks computer usage by IP address, and the computer would have the same IP address no matter what username you use. And so what they explained, they gave context, is that Chelsea Manning was just a soldier in a fob in an army base and kind of bored in Iraq, and would listen to music. She and played video games, and so she was trying to use a different username to download video games to her computer, just the way that several other soldiers were doing.
Mm-hmm. and it was said that this was a very common practice amongst a lot of soldiers. It wasn't just Chelsea Manning.
I think one of her superiors actually asked her to install software on her computer, so
Yeah.
she was seen as a technical expert among her peers.
The fascinating thing about this woman is she's the one who stood up on the witness stand during the trial. Nathan probably remembers this, and attacked Chelsea Manning's patriotism. Meanwhile, she's encouraging her, I guess, someone she oversees to engage in what is actually a
To
crime.
break the law.
It's
Yeah.
actually a crime.
Yeah.
Sorry, I just want to say that what I found the most shocking today, since you were asking earlier, is that none of these arguments were at all countered by the prosecution today. And it gave me the feeling that actually they probably won't be. Their tactic or their strategy is probably to avoid entering into any of these debates, or, just simply because all of this is on the public record. It's very difficult to counter these arguments. There's a lot of evidence. So I think their strategy is simply to focus, to hone in on those one or two very technical legal details, and to try to sort of push the entire conversation in that, or keep it, maintain it in that corner, and not even to let it go, to completely ignore all these arguments. And I was quite sort of shocked and saddened by that, because that's going to make it very difficult if there's no need to even counter these very strong. Some of the arguments I found by the defense yesterday were extremely strong, and I would have loved to hear what the prosecution was going to say about them.
Yeah, in several different areas, the U.S. is just very selective about what they decide to focus on, and that's their method of misinterpreting the whole narrative. And so it's definitely far more enlightening to hear Chelsea Manning's chronology than the selective parts of the prosecution. That came up a few times, their selectivity.
Like yesterday, what was amazing to me at the end of the day is after the defense put forward all of this information that, as you say, you should respond to, we then get this cop-out answer to what we just heard, that these were all just general allegations, that the most wanted leaks list is in the general allegations part of the indictment, and so they're not trying to link it to any specific disclosures. And what I tried to do in my reporting is go back over the indictment and show that, in fact, the most wanted leaks list is connected in the indictment to the war logs, to the cables, and that they're saying that because she saw the list, she's making this disclosure. But I think that's an example of the way the prosecution is trying to they're altering the meaning of language before the judge as a way to muddy everything and make it possible for them to get Julian Assange to the United States. I want to make a quick point here about what is happening with the UK prosecutors in general. Their goal and what they have to do for the United States is get Julian Assange to US soil. And once we see Julian Assange in US soil, hypothetically, obviously we don't want him to end up in the United States, but once he does get there, if he's there, we're in uncharted territory. And to some degree, what they are making a bones of contention in these proceedings, he may not be able to raise under the Espionage Act in the United States. Well, first off, we've never had a journalist prosecuted under the Espionage Act in the United States. But I will remind people who have some familiarity about whistleblowers that it's a strict liability offense, and Assange would be extremely limited in being able to describe his motivations and his intent when he published these documents. And we don't really know. We haven't heard anything litigated or argued in these proceedings during this week about the First Amendment issue, and I don't know that we will, but it's possible that the carve-out, the way to get around issues, the freedom of speech issues in the United States, is going to be, if we prove that it happened, then that's what we have to do, is just prove that it happened, and then you criminalize the conduct, and it doesn't matter what Julian Assange thinks. And in fact, the best that Julian Assange can do is what Chelsea Manning did, is find some way to get a statement into the court proceedings so that the public can hear from him why he did what he did. But he shouldn't have to explain because he's a journalist and there should be press freedom.
Yeah, before we do get into the First Amendment in particular and how this case is very serious and will not only impact journalists, but impact just average citizens and impact their right to know. I think it's really important when talking about this case. Many people can hear about it and think, oh, I'm not a journalist, this won't impact me. It certainly does. It certainly does. But I want to thank everybody who's watching right now. Thank you for watching us. We just started to do this podcast because we are covering the Assange extradition hearings in London. And then also make sure you do retweet the link so we could get more people watching this, so we can expose more people to this information. We know that oftentimes this is not discussed in corporate media. It is more so now, but we're really getting into depth here. And I'm with people right now who are in the courtroom, so they know firsthand exactly what happened. I would like to get maybe some of your thoughts in here as well with the First Amendment and the assault on the free press that is at stake here.
I could just say a little bit more about what Kevin was talking about, the fact that defendants under the Espionage Act are not allowed to present any public interest defense or explain their motives. Meanwhile, the government gets to say whatever they want about the motives on the other hand. So they get to paint Manning and especially Assange over these last couple of days as someone with really reckless disregard for what will happen if he publishes this information. And so we haven't talked about it that much yet, but that was a big focus of yesterday's hearing as well, was so in 2010, November of 2010, WikiLeaks began releasing Cablegate, the State Department cables. 250,000 of them, but it just began. It didn't release all of them. It was working with a series of media partners to, very specifically, Julian Assange has said, is a harm minimization process. WikiLeaks even would work with these organizations to redact information, even using a script to automatically, like robotically, redact all names just to protect sources who could potentially be named. But then fast forward to September 2011, and this is how the government would have it. Doesn't really matter what happens in between, is that just fast forward September 2011, WikiLeaks publishes the unredacted file of all 250,000 cables. But what happens in between is incredibly important. And as you were saying, the selectivity here is really dangerous and super misrepresenting of the facts. What actually happened was, as we talked about in court, so one of the media partners WikiLeaks was working with in 2010 was The Guardian, and David Lee and Luke Harding worked with WikiLeaks on those 2010 disclosures, and together wrote a book that was published in February 2011. So they're making money themselves personally off of these leaks. And we learned that one of the chapter titles of that book was a password to an encrypted file that had all of the unredacted cables. And they put that password on the chapter title of the book, published the book with no double checking of, oh, maybe I should check that password won't release 250,000 cables.
Can I just quickly say, it was a very interesting moment in court, actually, because when that came up, the prosecution lawyer didn't even know that was the case. Did not know that, and the defense showed him the book, and he kind of was incredulous. He was like, what, really? Yeah. Because that's been public knowledge for people that have followed this, but I thought that was a really extraordinary moment. But sorry. No, so February 2011 was when that book was published, that password was published. Luckily, people didn't put it two and two together for a while. It was kind of a complicated way to figure out how that password should be used. But in August 2011, somebody did figure that out and made that known to WikiLeaks and to others. And others began mirroring WikiLeaks site and posting the unredacted cables. As soon as WikiLeaks found out, as soon as Assange found out, they sprung right into action, warning people about this. And Julian Assange himself called the White House, and Sarah Harrison called the State Department, working for WikiLeaks, called the State Department, saying, like, this is an emergency. Assange specifically said, lives are at risk here. And he was
told that he had the emergency line to the White House, to the U.S. government, and then was told, well, just call back in a couple hours, and we'll get to it. And he said he was incredulous himself, saying, like, I don't understand why you don't have urgency here. People's lives are at risk. The U.S. government certainly doesn't want that in the record, doesn't want that discussed. So yeah, again, very selective about what they choose to focus on.
And the interesting thing is that not only is all this stuff on the public record and very easily sort of searchable and findable, but this is actually, this whole scene of him calling the State Department and or the White House, and Sarah Harrison doing that is in Laura Poitras's film.
Right, it's on video.
Risk.
Yeah.
So it's you can just watch it on Netflix. It's on Netflix now. Anyone can see it. Like the evidence is so readily available, and the fact that the prosecution was sort of surprised by it, or at least appeared to be surprised by that chronology was kind of.
When that came up in court, I kind of noticed on Twitter some other journalists who had worked with WikiLeaks at the time in 2010 said that they personally attested to Assange's deep caring for minimizing harm. He's cared very seriously about redactions and not putting innocent people's lives at risk, and they were attesting to that on Twitter, live as this was going on.
And I think this is, again, probably not public knowledge to people that follow this, but it was mentioned in the court how the WikiLeaks redaction process was so thorough that it was actually more thorough than some of the Pentagon's own redaction when things had come out through FOIA requests and things of that nature.
Right, yeah, they redacted more than the government did, more than other media organizations did, but that's not what the government wants to focus on.
And I guess in terms of other misconceptions that are worth correcting, as we talked a little bit about the most wanted list, we kind of had a long discussion yesterday of how, what was on that list and what Manning had provided to Assange was completely different. Documents that WikiLeaks had wanted were not received, and vice versa. So I think that's worth.
But more than that, it was not even something that WikiLeaks put out. It's like, this is exactly what we want. That's why WikiLeaks is called a wiki. It's collaborative. And they invited journalists and human rights defenders and activists. Put on this list what you want, what would be really useful for your work, and giving the public better access to what your government is doing. And so it was a collaborative effort. Other people were putting that on. It's not Assange specifically asking for certain documents. It's a collaborative thing. And
just very quickly about the interesting thing about 2 points about the points of omission is that we had a very good point on our discussion on Monday, is that we hear a lot about the amount of harm that Julian Assange allegedly put people in. We never actually have a discussion about the amount of war crimes that were disclosed, or that in relation to one another is a very stark contrast, isn't there? I forgot the other point I was going to make, so I'm going to hand it.
I was very glad.
You saw me kind of reaching for the mic. I just wanted to build off of some of the points that you were making as well. At least in the early days of WikiLeaks, I believe that it had to rely on other media partners, essentially, to get the information out there. Not just collaborators, but also they relied on the media to report on these leaks. And just for everybody who's watching, if you don't already know this, I know many people that follow the case do, but WikiLeaks has a 100% accuracy rate in reporting, and also are very dedicated to source protection and helping whistleblowers. And we have the director of Courage Foundation with us as well, which is a great organization. And I'd like you to talk about that before we wrap up later on. And I talked about the series of events that you guys held in the United States, which were awesome, and maybe there will be some more of them. Yes, I attended 2 of them. They were great. And it was interesting also during these events to hear from people who knew Julian personally, who know him, and who spent quite a bit of time with him and said that he was a person of high moral integrity. And then that really is reflected in how he and others working for WikiLeaks, other staff members, took the time to make sure that these names were redacted to minimize potential harm.
I was just thinking that one of the things that we haven't mentioned yet is that the U.S. government was actually involved in the redaction process, and that was a very strong argument as well. that isn't mentioned a lot. And two of the journalists that were involved with the Spiegel at the time, they gave a talk at the Bundestag, at the German Parliament, and testified to how strict WikiLeaks was about protecting sources and about the whole redaction process. And actually, John Goetz, who was also mentioned a lot yesterday, he at that time said that how annoyed he and the others were, and that they would talk about WikiLeaks badly because they were so strict about encryption and about all this stuff, which, you know, now it seems totally normal, but at the time it seemed totally, they thought it was completely paranoid and totally over the top how, you know, strict they were about trying to protect this data and trying to, you know, not let it go out into the world unredacted. So it's, yeah.
And I think the point that you just raised about how the US State Department was helping with the redactions, I guess can lead us on to a very good point of, I think the main thing that came out of yesterday was that the US prosecution or the indictment, the case was made by the defense that it's willfully misconstrues the facts of the case, and that is a very good example of that. Is that WikiLeaks were actually State Department was helping WikiLeaks in the redaction, so to kind of make the claim that WikiLeaks is recklessly putting lives at risk is knowingly untrue because they're involved in that process.
And the government's argument was that you can't talk about that. You just have to look at what's in the extradition request. Don't even look at the indictment, just what's in the extradition request, the way it's phrased. And so really trying to limit what the judge can look at in this case and try to really narrow it, make that decision harder for her.
And I found sometimes almost rude the way the prosecution was telling the judge, you know, this is not your jurisdiction. All you have to decide on is what, like, basically saying all of this is none of your business. You have, you know, nothing to say on all this. Leave that up to us. He'll have a fair trial in America. All you need to decide is whether or not he can be extradited, and ignore all, you know,
right.
all this.
All they
evidence.
want them to look at is what's called dual criminality. If it's a crime in the U.S., is it also a crime in the U.K.? That's all they want them to look at. But what the defense is arguing is that it so misrepresents the facts, that so misconstrues things as to constitute an abuse of process. And so that's the way that they're challenging this extradition so far.
Well, and then from that, what extends is they're making the argument that Julian Assange is in Belmarsh prison, denied bail, and so he's arbitrarily detained, and his due process rights are being violated because you have put forward an indictment that is false, improper, and, you know, plays fast and loose with the facts. And in doing so, only because you're doing that, are you able to justify keeping him in prison. Only by doing that are you able to convince the judge that Julian Assange should be in prison, not out on bail. And so without that, you know, this has been really why we're trapped in this kind of a case.
I think one thing that may be important to clarify here is who has the burden to show evidence, like what side does. I'm not sure if the standard is proof, but is it up to the defense to show that this extradition should not happen?
Well, so the defense framed it as they're bringing an abuse of process allegation against this request. So they're saying that the judge should decide on whether the request itself is abusive in its nature by misrepresenting the facts. There are several factors, but one of them is how willfully it misrepresents the facts. So it's framed as, and actually that's interesting, the judge asked, like, what do you want me to rule on here early on in the court? And one of the things was whether this is an abuse of process.
And I guess one thing that was relevant to that was, lost my point there, but the one of the things that came out about the abusive process was, I'm completely losing my point here. You're gonna have to.
I could go back to.
Maybe if you could, yeah. Why don't you pick it up?
I just want to say something about that you mentioned earlier that I think should get a lot more attention, is that we never get focus on what WikiLeaks disclosed on the war crimes. And I was so glad that yesterday we actually heard about collateral murder as a war crime, as and the defense described it as a genuinely chilling video. And we finally, I mean, this isn't the proper way. They should be doing it in The Hague, but finally we get U.S. war crimes mentioned in a courtroom here. And so, as Kevin was saying, it's amazing how the government wants to paint Assange as just the coach who used Chelsea Manning as a pawn, basically completely denying her whistleblowing agency when
structured their statements to the court. They're reminding, or perhaps informing the judge for the first time. We don't know. I don't know what kind of knowledge she has of WikiLeaks disclosures and publications and the kind of impact it had on the world.